the member for Perth on the screen, so I think we'll go to the member for Warringah. The member for Warringah has the call.
Thank you, Mr Deputy Speaker. These bills will make considerable changes to our electoral laws, and these changes come as a result of the recommendation of the Government Majority Joint Standing Committee on Electoral Matters in their 2019 report and on the federal election. It's really concerning that the government has decided to push these bills through at a time where the lower house is sitting in absolute minimal numbers, at a time where there will be minimal scrutiny on these major changes to our electoral laws. And I have to, as I sit here listening to speakers from both sides of the House, and in particular Labor speakers, I have to feel just how opportunistic it is that we hear them one after the other speak about the importance of democracy and upholding democracy and scrutiny. But the only time we ever hear of that strong bipartisan support is when the major parties are ultimately desperately trying to hold on to a two major party system of politics. That is when there is definitely that they come together to really ensure that they maintain their monopoly and their status. We know from election to election, the primary vote for major parties continues to decrease. And the cynic in me would say this is a major aspect that is trying to be addressed by trying to cut off competition. These bills go to the very foundation of our democracy, our right to vote, politically organised, and they should not be pushed through under the cover of COVID-19. In particular, the Party Registration Integrity Bill. So this bill amends registration eligibility requirements for a federal non-parliamentary party, i.e. someone who has not already got someone elected. The amendment will increase the minimum membership requirements for registration from 500 to 1,500 unique members. And if the bill passes, parties will have just 3 months to demonstrate they have 1,500 members. Now, of course, it's easy for the major parties to be happy with this proposal. They don't have to worry. It's not going to challenge. What it is doing is getting rid of competition. It's getting rid of challenge. And no matter what the ideological basis is, that is ultimately what this will do. The bills also amend prohibitions regarding registrable names, abbreviations and logos. It really, for example, if a party replicates a name, abbreviation or logo of an already registered name without consent, it will be a contravention of this amendment and the Electoral Commission will refuse registration. So first, unique membership is really the one that I think has garnered more attention. By moving from minimum membership to go from 500 to 1,500, you're impeding individuals' right to politically organise. That's what you're really doing. It will decrease participation in our parliamentary democracy by increasing barriers to entry. And I'm particularly concerned that this change will make it difficult for parties in smaller states and territories to organise and form a party. For example, Kim Rubenstein, in the ACT. She's an acclaimed constitutional lawyer and advocate for women's rights. She is the exact type of person that we need in Parliament. And I'm pleased to see her announcement last week that she's running for the Senate seat in the ACT. She wants to challenge the duopoly of the major parties who both assume that each of them will take one seat each. What a comfortable arrangement, isn't it? In her efforts to be on an equal footing with those parties, she's looking to form a party to ensure she can be above the line, but potential signatories is limited due it's a smaller jurisdiction. And that job of gaining equality with the major parties will be made that much harder by now the introduction of this party registrations bill. I don't hear the members of the opposition of Labor talking about those aspects. It's always very convenient to talk about the importance of upholding democracy and improving our democratic system, but only when it also is convenient to them. Or in the House of Representatives, for individuals focused on a particular electorate only, rather than a broader support base across a state or even a nation, if they want to form a party and benefit from the advantages that would bring, this amendment makes it that much harder. So essentially we're saying that party can only be if it's aiming at national representation. You take away that opportunity for more local, regionally based party system. And it's alarming that the Parliament and that the government is choosing to crack down in this way. And I can only describe it as a naked attempt to consolidate power for major parties, and that Labor is talking its virtues, that it is such a bipartisan approach is only because it will also benefit them. In effect, these bills reduce political competition, and so anyone who believes in a strong crossbench in either chamber or in either chamber of this House should be about these changes. I have no doubt this is an attempt to muzzle the influence of minor parties and the crossbench. It's an unduly restrictive change and it should be opposed. In relation to the names, it's again an attempt to reduce political competition. It's fairly obvious that to neutralise new threats, and I don't believe in their ideologies, but I do believe in competition. And the threat to government members from parties like, say, the New Liberals or the Liberal Democrats, that there now wants to be an idea that you can monopolise the word Liberal. They don't own the Liberal concept. Government and Liberal Party doesn't own the Liberal concept. Just like the concept of Democrat, there is equivalent to giving political entities intellectual property rights over words. It's a minefield for potential legal challenges. There will be extensive disagreement of what each word means and if it's linked to another registered entity. The word liberal means something very different in different countries around the world and in different contexts. This amendment is, I would argue, an entirely anti-liberal push. And by liberal, I mean small L liberal. Liberalism being a political and moral philosophy based on liberty, consent of the governed and equality before the law. It is anti-liberal, anti-competitive and anti-democratic, these changes. Political campaigners. Now, regarding the political campaigners bill, this bill will lower the expenditure threshold for political campaigners from $500,000 to $100,000. This is, again, an attempt to control smaller political actors by forcing them to register and jump through bureaucratic hoops. It will increase the barriers to participate in the federal election for many individuals and organisations, and it will particularly affect charities and smaller NGOs, exactly the kind of actors who are essential to a functioning and healthy democracy, for challenging the views and the spin that is churned out at election time by the major parties. The government is pursuing these anti-democratic laws whilst ignoring the reforms that actually could make a positive effect on our political discourse. What we really need to be doing is tightening up truth in political advertising laws. Major parties shamelessly weaponise myth, truth, lies to win elections. We've seen it with the death tax campaign in 2019 and we saw it with the Mediscare campaign in 2016. And the community is fed up with it. According to polling by the Australian Institute, 87% of people support truth in political laws. But where is it? Where is that legislation introduced? Nowhere. And that's why I will be introducing a private members bill to introduce truth in political advertising. Just 1 in 4 Australians have confidence in their political representatives. By 2025, if the trend continues, only 10% of the public will trust politicians. We must reverse this trend. It's not a big ask. Managing truth in advertising is not unusual. There is corporations law that prevents misleading and deceptive advertising by businesses, and there are enforcement bodies in place to keep an eye on it. And there is no law or body to stop politicians or third parties from lying about a candidate or their opponent during an election campaign. That is outrageous. This year, we've seen a number of examples of misleading and deceptive advertising, including from members of Parliament and political parties, without current representation in the Australian Parliament. We can look to other jurisdictions for successful examples. Truth in advertising laws have been in place in South Australia for over 20 years. They've been adopted in the ACT last year. We can and should progress this reform, and I look forward to having a debate on the bill to be introduced by me as a private member's bill later in the year. Overall, I'm concerned that these changes ultimately undermine our democracy. Minor parties, charities and NGOs are essential at maintaining a healthy democracy. They bring different elements of discourse, they bring different priorities and they bring scrutiny. Who else will hold the major parties to account if not them? Mr Deputy Speaker, these bills are a shameless attempt to consolidate power and should be rejected. If the government is serious about electoral reform, it must consider meaningful reforms like tidying up political advertising and donation laws. Only then will our public regain, again, some hope of trusting politics and politicians. Thank you.
The